Thank you very much. So as it was announced already, this will be a joint presentation by me and our dear friend and colleague, José. I'm aware that I'm now already seriously invading your lunchtime, so we will try to be as brief as possible with our presentation. So as you can see, the topic of our presentation is comparative law outlines common core of the concept of legally binding or res judicata. So as my predecessor Tom already said, what the heck is common core, of course? Well, common core is actually a methodology or technique of research which is applied in comparative law. It traces its origin back to 60s, actually 1968, to the methodology for the first time applied by Schlesinger, where he was researching hypothetical cases on the basis of functional analysis, trying to find emerging themes of agreement regarding the topic which was object of research, and it was about contract law. So this methodology was later successfully, we could say, applied in the research of European civil law in several successive projects. The Trento project later continued as Turin project and finally as a common core project. And this, I will call it Trentian approach, was very similar to Schlesinger's approach. It was based on hypothetical cases, which are supposed to be solved in different legal orders, and they were trying to search for, of course, solution of a case, but also interactions and contradictions of different legal orders, and how policy considerations, values, economic and social factors, and procedural rules may affect the solution of the case. Of course, this Trentian project was not about procedural law, it was about substantive law, but they took in account also the effect of the procedural law it might have on the outcome of the case. So, of course, the results of such methodological approaches trying to identify the elements of such existing common core of various legal orders, and we can try to identify what they were searching for. So whether there exists some common traditions, either original or invented or reinvented traditions, which might be common to different legal orders. Then they were searching for similar considerations or rationale for decision making, common values, common economic and social factors. They were searching for similar normative and doctrinal treating of phenomena, either familiarity of expression, either meaning of expression. They were, of course, searching for similar functions in different legal orders, regardless to the normative expression in certain legal order, and this was based on hypothetical cases. And then, of course, they were searching for widespread perception of different legal concepts and by the end, you would already recognize patterns of existing common principles in different legal orders. So basically, if we want to research common core of res judicata or whatever else within this project, this is what we have to do. And all those of you who are writing national reports or were involved in either drafting or evaluating the national reports notice that there are such hypothetical cases which are to be applied for the function analysis and might serve for this search for a common core. So let me briefly continue with the knowledge we have at this point of time. We can say that if we talk about res judicata, we can easily find at least that there exists some common tradition, either original, I'd say it's more reinvented tradition, but we can easily see that we are referring to the Roman law times, and we can find fragments of something which will later become the res judicata doctrine existing in the Justinian Code and in the Digest and Institutes. And we can also see that courts of different states and legal scholars are referring to various legal maxims in Latin. So by referring by this to this common tradition of Roman law, as I said, we shouldn't take it too serious because it's obviously to a great part reinvented, but obviously there exists some kind of sense that there is some historical common root existing and binding us with these times. Then, of course, we can also recognize that judges, legislators, courts of different countries share very similar policies which they're pursuing in their action. That we can recognize similarity of rationale, and this is some kind of trade-off between material truth and individual and social interest to conclude the litigation at a certain point of time, so not to have perpetuated litigation. Then we have this policy that judgment need to be authoritative solution for a case and have binding effects for subjects involved in this case, and also third parties, and that there should be no perpetual reopening of a case, so that there should be some kind of preclusive effect. Of course, there are many sorts of preclusive effects, but there is a general agreement that there should be some kind of preclusive effect. So the problem me and Jose had preparing this presentation is, of course, that, as you now already know, we should have made a serious research of our national reports, especially the part of the cases, hypothetical cases, and then trying to search for those patterns. But unfortunately, we did not receive yet all the national reports, and not all received national reports were dealing with res judicata or were not finished yet. So we had to, of course, we considered the received data as well, but we had to take a shortcut. And we had to, of course, resort to the state of the art of research existing at this time. And we could say that luckily we have very comprehensive comparative research dealing with res judicata issues. That's this project of British Institute from 2008 with the comparative report for Spain, England and Wales, Germany, Sweden, France, Switzerland, Romania, United States and the Netherlands. So we could say that at least regarding the res judicata, well, we are some kind of continuation of this project. So because my time is now already lapsing, I will be very brief. Well, we can say that based on the comparative data we've seen, we could say that there are generally recognized main effects of judgment shared by all legal systems, and that is that final determination and findings on issues of facts and law should arise out of the judgment, that all judgment should have binding effects, and that all judgment should have preclusive effects. And when we are talking about finality, we could say that we could talk about finality of a judgment, meaning that no court besides the competent appellate court can decide on the validity of existing judgment, and that there are some bearing effects for parties to even try such attacks. Then there we can talk about finality within the case, meaning that court is prohibited from reopening in the remainder of the case matters it has finally determined, and also that there are some bearing effects for the parties to relitigate such matters. And there is also finality in another case, meaning that legal system has some bearing rules for litigation of matters that were previously already determined or could or should have been determined. And when we talk about this finality in another case, we could also say that this preclusion effects, which can also have three versions. It's a preclusion of claim, preclusion of issue, and wider preclusive effects. When we talk about preclusions, here we also can identify three types of preclusion. It's preclusion of claim, which we could say is more or less general principles in all legal orders. We can have issue preclusion, which is yet again a general rule which we can identify in all legal orders, and then there are wider preclusive effects where we can say that most of legal orders are familiar with this wider preclusive effects, but we can identify very different solutions in legal orders existing. So at this point, I will cease with my part of presentation and I am handing the floor to José to continue with next part. Thank you.
Okay, thank you, Tomaž. Hi, guys. It's great to be with you again, even though it's online, so we can talk, we can see each other, but we can't have a drink together. Well, actually, we might, if we get some, so if we get imaginative, I think we probably could do it as well. But anyway, hopefully in the future it will change and we will be together again, live somewhere in this Europe of us. Well, Tomaž basically has been telling you just about everything we could dig out of the subject that we had to deal with. He covered methodology, he covered state of the art, he covered already a little bit of what we managed to squeeze in the very short time that we had after receiving not that many national reports. The questionnaire for that national reporters have been answering has 4 sections dealing with the subjects that do have something to do with the res judicata. Sections 5, 6, 7, and 8. Section 5 covers just about almost everything, including the cases. Sections 6, 7, and 8, they detail some smaller aspects of the res judicata issue. Those were the reports that were available. You might recall that when in one of the last slides we sort of considered that some of national reports this time would be additional data because they were not they were dealing with jurisdictions not dealt previously in the British Comparative Law Institute project, and some other projects, some other reports would be considered verification data or validation data. So basically we were revisiting some jurisdictions and looking at the previous work and double checking with our work. Tomaž, can you please move on? Thank you. So we don't, of course, we had some problems. The biggest problem that we had, some of you, most of you know that we have to build out of the reports, we have to build a comparative table. Now, this time it was challenging because not only we didn't have enough data to fill in the table for all the jurisdictions that were involved, we had yet another one. I discovered this time that an Excel cell actually has a text limit because some answers were so big, so extensive, I just couldn't fit those answers there. So imagine what it's like to do some comparative work, which basically uses this tool, and we have to cherry pick maybe 10 to 15 words out of 3 or 4 pages. So you can imagine the hard time that we have with that. And because of this, just heads up, I think we will probably bother some of you to give us some much smaller answers to a couple of questions that we may have to try to rebuild and polish the work we've done. Now, what additional findings that have we found? The timing of res judicata. It seems that this is also something which is quite common. Res judicata, it's the final decision, although it might be a partial decision, not an overall decision, a final judgment. But the thing is, when there is exhaustion of judicial power on a subject matter, then that's in general when res judicata exists. Sometimes it doesn't have different names, but the function is quite similar. As to enforceability, well, enforceability is usually, at least the final enforceability is usually connected to res judicata as a consequence of it. And under certain circumstances, there may be provisional enforceability, but most of the time that will be subject to some conditions. And the extra jurisdiction scope of res judicata that would fall within the wider preclusion that we dealt with cases in section 5.5 is generally recognized with some few exceptions, especially the ones regarding to dictum on the statement of reasons. Finally, erga omnes effect. There are very limited instances of erga omnes effects. The general principle is that res judicata operates between the parties. And next, please. Final results. There is binding and exclusive effects. They are recognized in all systems. Doctrine about it may be different, but by the end of the day, It's not that functionally different. There are some significant operational differences, and terminology is quite often quite different. I mean, I've got this feeling, even today, I had this feeling that some of us listening, for instance, to Tom and some of the national reports, the general idea of the concept of res judicata is quite different. Uh, Listening to the name, although the institution exists, the function exists, the effects exist, and they are similar, we don't understand the expression, the designation in exactly the same way, and sometimes it's surprising, I must tell you. Right, I don't want to, Tomaž, I don't want to delay lunch for everybody else. In Portugal, it's a little bit too early for lunch, and I suppose in the UK as well. But all the rest in continental Europe are probably longing for lunch. I know Wolf is. So I won't stand in the way. Thank you very much. And there is a common core after all. Thank you.